Welcome, everybody. My name is Shaista Kazi, and I would like to warmly welcome everyone to the mediation training program hosted by ISS, the Global Social Services Organization. It seems I was muted. Justin, am I still muted?
No,
Okay.
you're not muted. You can go ahead.
As I was saying, hosted by the Global Social Services Organization in collaboration with PAVASA, the Pan-African Bar Association of South Africa. And particularly, sorry, I'm getting admission requests.
Just ignore them, Shaita, we'll attend to them.
Okay. Honorable Judge President Nambo, judges of the High Court, members of the profession participating in this course, we warmly welcome you and appreciate your attendance after hours and in all the jurisdictions that our participants and our trainers come from. We really appreciate you prioritizing this important course. I would like to introduce our first speaker this afternoon and the pillar of strength behind organizing and cajoling and bringing this course to fruition, Dr. Mohamed Keshavjee. Dr. Keshavjee is a South African-born barrister and was called to the bar at Gray's Inn in London. He holds degrees from Queen's University in Canada and from my alma mater, the Social School of Oriental and African Studies, University of London. He is the author of 4 books, including Into That Heaven of Freedom, The Impact of Apartheid on an Indian Family's Diasporic History. Dr. Keshavjee is an international specialist on cross-cultural mediation with training from the Harvard Law School in Massachusetts, the Berghoff Foundation in Berlin, and Child Focus in Belgium. Dr. Keshavjee has trained pastors and imams in mediation in the USA and the United Kingdom, respectively. A former member of the steering committee of the World Mediation Forum, a position he held for 2 terms, and Dr. Keshavjee was responsible for conceptualizing and implementing the mediation programs for the conciliation and arbitration boards of the Ismaili Muslim community worldwide, training some 1,500 mediators in over 25 countries in family and commercial disputes. From 2000 to 2012, the doctor was a keynote speaker at major conferences on mediation held in Buenos Aires, Crans-Montana, Strasbourg, Paris, Galway, Eindhoven, Vilnius, and Edmonton. I hope I pronounced those cities appropriately and correctly. In 2012, he was invited by the Secretary General of the Hague Conference on Private International Law to Malta to address the 4th International Conference on International Interspousal Child Abduction, where he helped draft the final resolution on mediation. Dr. Keshavjee is a member of the advisory panel on mediation to the Secretary General of the International Social Service of Geneva and holds a senior faculty position with the Darwin International Institute for the Study of Compassion, where he has lectured frequently on their scholarship program. In 2016, for his global work on peace and human rights education, Dr. Keshavjee was conferred the Gandhi King Ikeda Peace Award at the 48th death anniversary of the Reverend Martin Luther King Jr., where he presented the memorial lecture. Dr. Keshavjee is presently based in London, where he lectures on law and mediation at the Institute of Ismaili Studies. He lives with his wife, Dr. Amina Jindani, a specialist on tuberculosis research, who is presently conducting a multi-center clinical trial involving Asia, Africa, and Latin American continents. Doctor, we are most disappointed that you are unable to physically join us in South Africa after so very many years, but we are thrilled to have you run such a fantastic course virtually. We welcome you.
Thank you, Shayishta, for those very warm words. Judge Jody Kollapen of the High Court of South Africa, Ms. Kathleen Matolo-Dlepu, Chair of the Legal Practice Council of South Africa and Commissioner of the Judicial Services Commission, Ms. Nasreen Rajab-Budlender of the Pan-African Bar Association of South Africa, His Honor Judge Dunstan Malambo, Judge President of the Gauteng Division of the High Court, honorable members of the judiciary, members of the legal profession, members of the civil society, participants of this program, ladies and gentlemen. Good afternoon to you in South Africa, and good day to others, wherever in the world you may be. On behalf of our international team of trainers and facilitators, and on my own behalf, I would like to extend my warmest gratitude to you all for helping to make this training program a reality. My special thanks go to you, Judge Kollapen, for your continued support for this endeavor ever since we first met in Pretoria in July 2019, when you chaired a meeting with a number of stakeholders extolling the virtue of mediation and the need for a training program of the kind I had proposed. Since then, your support has always been with us in this endeavor. I'm also deeply grateful to you, Ms. Dlepu, for your support in this endeavor. I also met you when I came to Pretoria, and you were most encouraging. Our endeavor today resonates with your concern of promoting sound legal education and ensuring access to justice to the most marginalized in society, something you have now been doing for many years. I'm very excited that a significant number of participants in this program are from your organization, and I thank you most warmly for this. To His Honor Judge Dunstan Malambo, I'm also very grateful. Your presence on this program today underscores the importance that the judiciary attaches to mediation. Thank you for being with us. Perhaps I should mention the genesis of this training program. The idea took birth on the south coast of Kenya in a sleepy village of Kwale on the Indian Ocean. This was in the year 2019, when a small group of trainers from 4 countries, myself included, responded to a request from a group of undergraduates from Kenya who wanted to learn the skills of mediation. As we got into discussions with them, we realized that they had no resources whatsoever to fly us out to Kenya. We discussed this among ourselves and decided to go there on our own resources and to help them. As we came closer to the program, we realized that they did not even have a physical space for training. We contacted a retired anthropologist working in the area who made his beach cottage called Aramesh available to us. And on this site, we built a makeshift school with a thatched roof. We even built a makeshift dormitory with ambulatory facilities. Over a 10-day period, we conducted a training program for 33 young graduates, both men and women. We developed a curriculum that was suited to the culture of the area. And we also succeeded in convincing the Geneva-based Office of the International Social Service to provide the certification for a 40-hour training program in family and commercial mediation. Here, I must pay special tribute to Mr. Jean Ayoub, the Secretary General of the International Social Service of Geneva, for putting his confidence in our teaching and sponsoring and certifying our program. I'm happy to inform you that from that program in Kenya, 5 students went on to higher education, 2 of them women from the village organizations who were offered opportunities to do a master's in conflict resolution in the United States of America. One of our trainees, a young lawyer, started his own mediation training organization, and since then has trained other villages in mediation. Another of our trainees ended up in a leadership program run by the African Union. For this program in Kenya, we had invited a few South African lawyers. Unfortunately, all could not come. The only one able to attend was a Pretoria advocate, Ms. Keshavjee, who came with her son, also a lawyer. They participated with the group and found the program fascinating in that, despite the paucity of creature comforts, there was an insatiable thirst for learning, matched only by the passion of an international team of trainers from Canada, United States, United Kingdom, and Switzerland to teach. At the end of the program, Harshila approached us to ask if we would come to South Africa to mount a similar program, and assured us that the venue and accommodation would be no problem in cosmopolitan Pretoria. She also told us that we would not have to travel 36 miles a day on rough Marram roads to reach our teaching venue. Lured by the possibility of a visit to beautiful South Africa, we all agreed immediately. I made one further request. Could it be during the beautiful jacaranda season, as I was born in the shadow of a jacaranda tree in Marabastad, and the tree is still extant? Harshila immediately responded, tempting us further with a trip to the magnificent wildlife lodges in Pilanesberg. In reality then, Ms. Harshila Keshavjee can be described as the mother of this training program. Sadly, no one envisaged at that time that we would soon be caught up in a global pandemic that would make us change gear and move towards a virtual program. Our small team of 6 dwindled down to 3, but slowly grew again into a training team of 20 enthusiastic people. And with time, we developed a new relationship with the Pan-African Bar Association of South Africa, whose key functionaries have been collaborating very closely with our international team from some 6 countries. I would like to thank Ms. Rajab-Budlender for the wonderful support that she has made available for this program. Nasreen, I'm not exaggerating when I say that without Pabasa, we would have been lost in the wilderness. Thank you for backing this endeavor so wholeheartedly. And thank you, Shaista, for being with us when Nasreen was tied up in court. Your presence, given your own background in conflict resolution from our common alma mater, the School of Oriental and African Studies, has been very valuable. What was more enjoyable is your educating us about the latest South African music and reminding me that Mona Lisa, Saduva, and Pata Pata are songs of yesteryear, and Jerusalem is now the in thing. This program today finds its inspiration in a concept pioneered by the Aga Khan, the Imam or spiritual leader of the Ismaili Muslims, who is a leading proponent of global and sustainable development. The Aga Khan strongly believes that one's education is of little value unless it is used both for one's own well-being and for that of others among whom one lives and who are in need. The Aga Khan does not view this as charity or philanthropy, but as the human obligation of each person to their fellow human beings in keeping with the fundamental principle of sharing in Islam. There is a saying attributed to Caliph Imam Ali that knowledge that is not shared becomes like an albatross around one's neck. The sentiment of sharing one's knowledge for the betterment of others that is so strongly embedded in the Ismaili tradition finds ready resonance with the Canadian ethic of sharing best practice in the fields of social governance, respect for pluralism and meritocracy, and the nurturing of a robust civil society as the cornerstones of a healthy and functioning democracy. It is in this spirit that Ismailis throughout the world volunteer their gifts, not only of wealth, but most notably of time and knowledge in support of the development work that the Ismaili Imamate is sponsoring worldwide under the aegis of the Aga Khan Development Network. The Ismaili community established a time and knowledge framework, a structured process for engaging an immense pool of expertise that involves a multitude of volunteers globally. Many of these volunteers have traveled to developing countries as part of this outpouring of service. Two of our present trainers, Ms. Ruxana Abdullah and Ray Virani, went out twice to Afghanistan to train members of the civil society in mediation. In this context, I would like to extend my warmest gratitude to the Time and Knowledge Office in Toronto, Canada, for introducing us to some of the volunteers who are part of this international team today, even though this program is not itself sponsored by the Aga Khan Development Network. As to the Canadian element in this equation, our lead trainer, Richard Harding, has spent countless hours in developing a suitable curriculum in close collaboration with our South African counterparts, who have been with us in all our deliberations. Richard has been ably assisted by his wife, Dr. Gwyneth Meyer, a well-respected Canadian academic and a practical educationist. Both Richard and Gwyneth have been inspired by the Christian faith to share their knowledge with others and draw from a range of influences in the best spirit of ecumenicism and generosity of heart. With that worldview, Richard has tried to ensure that our training program resonates with the needs of South Africa and is culturally relevant. In this process, Advocate Linda Retief has been a great support. She has guided us throughout all our planning discussions. From Canada also, we have Mr. Brad Mustard, a lawyer and a mediator, who is a specialist in online mediation. Brad has very kindly agreed to present one session on online training for this program and has generously shared his teaching materials with us. We have been equally fortunate to enlist the help of Mr. Henry Brown, a veteran South African attorney who has had years of experience as a mediator and was a founder member of the Center for Effective Dispute Resolution, known by the acronym CEDR, C-E-D-R. Inspired by his Jewish faith, Henry has served the cause of social justice for many years as an attorney representing political prisoners, including Mr. Mandela, during his very early days on Robben Island. Henry continued to serve the cause of justice in South Africa as a solicitor in England when he arrived there in the 1970s. Henry co-ran a mediation training program for the Family and Marriage Society of South Africa in Cape Town in 1992 and again in 1994. He has very kindly agreed to run the civil and commercial mediation segment of this training program. He will be ably assisted in this by Ray Virani of Atlanta. The challenges we have faced in getting this program up and running have been enormous. I must confess, after running training programs in over 25 countries, including Afghanistan, Syria, Pakistan, India, and Tajikistan, that the challenges posed by the South African program have been unique. This is because, excuse me, the program is virtual and is being implemented from a number of time zones in a field where communication is critical, and taking into consideration that 83% of all communication is through body language, you can well imagine how challenging it is to mount a program of this nature virtually, requiring breakout rooms for role plays and the ability for the faculty to move from one room to another, sometimes even without being noticed. Here we have been ably served by Akbar Sayani of Atlanta, who has worked tirelessly over the past 12 months in ensuring that our curriculum is geared to virtual delivery. He has been assisted in this process by a dedicated team of volunteers, attorney Nadim Kurji of Ontario, Anis Nanji, Anar Hirji, and Rahim Assar, all of Toronto, introduced to us by the Time and Knowledge Office of the Aga Khan community in Canada, and Rahil Savani of Uganda, a budding attorney. As we came closer to countdown, we realized that a program of this nature required more sophisticated technical assistance. For this, we turned to Shan Momin of Atlanta, himself an attorney and a trainer in this field from the International Conciliation and Arbitration Board. Shan shared his experience with us and ran a small tutorial for us through which Akbar and Charlotte Williams of Pabasa revamped our whole delivery system, getting Justin Holthausen, an expert on Zoom Pro, on board. Together, they organized rehearsals for each of our presenters over a 10-day period. I would like to extend my warmest gratitude to our entire tech team for the wonderful work they have done. To Charlotte, I would say, hooray, you have kept us all on the rails. In this context, I only have two entreaties to make of our participants. The first is, please bear with us. We are dealing with some new technological challenges which are daunting, and we will try everything possible to ensure smooth sailing. But if systems break down, please be patient with us and help us find effective solutions. Secondly, please keep in mind that all the individuals in this team are volunteers who've been working tirelessly for the past 18 months to ensure that we give you a program that is robust, sustainable, and of international standard. Looking to the future, what are some of the things we should be thinking of? May I leave you with a few thoughts for reflection, and hopefully we will devote one session at the end of this program to flesh these out and come up with some practical suggestions that can be entrepreneurially followed up. For this, we will be working with our South African counterparts and two ex-chairs from the National Conciliation and Arbitration Boards of the United States of America and Canada. They are Mr. Ashraf Ramji, an attorney, and Mr. Karim Sundarji, a business entrepreneur, respectively, both with at least 20 years of experience as senior mediators, to share their learning in their respective countries. While it becomes important to ensure that this training program becomes a sustainable process and not just an episode, important long-term policy implications will need to be seriously reflected upon. There are 5 that come to mind, and I will briefly outline them. Firstly, how can we inculcate the culture of mediation as a dispute resolution mechanism across all levels of South African society? We have started now with the judiciary and the legal profession, and it could be justifiably argued that this is a top-down approach and that we also need a bottom-up one. I feel that both the approaches are needed and would humbly suggest that as we move forward, serious consideration be given to this issue. Secondly, how can we pivot from this first exploratory training program into a long-term sustainable one that is institutionalized and viable? Here, I would only make 2 small points. The proceeds from this training program, after costs have been defrayed, will remain in South Africa as the international training team's humble contribution in providing some seed money for future training programs in South Africa. We also remain committed to helping South Africa with all our international connections in the field of mediation, should you want to further develop your own faculty someday. Thirdly, and very importantly, how do we ensure that alternative justice does not degenerate into inferior justice? This could easily happen if we do not put into place certain structures to oversee the practice of mediation in South Africa. These include effective regulatory procedures, ongoing refresher programs, ensuring greater professional accountability, and most critically, ensuring that mediators in South Africa are able to earn a decent living so that the profession is able to attract some of the best people in society. Here, members of the judiciary, the legal profession, and civil society have to work in close synergy to ensure that mediation finds an integral part in the dispute resolution landscape of South Africa. Fourthly, how do we embrace some of the traditional processes of dispute resolution that exist in all communities and cultures, ranging from traditional systems and community practices based on faith traditions to those processes used by professional organizations and guilds? We need to ensure that culturally sensitive refurbishment takes place from time to time, using community functionaries to embrace change through contemporary ADR practices without losing the basic ethical values that make up such polities. Lastly, how do we ensure in a country like South Africa, through ADR, that we are able to secure equal access to justice for all? This is not an easy task, but my feeling is that if we can place mediation in South Africa on a sound footing as a genuine alternative to litigation, we will have taken important strides in this area of social justice. It could be a win-win situation for all, whereby the courts in the country will not be burdened unnecessarily with cases that can be resolved at the community level. At the same time, it'll give people an opportunity to resolve their problems in a manner that is resonant with their cultures, their traditions, their values, and their sentiments, faith-based or otherwise, but always, always within the shadow of the law. These are some of the long-term issues that alternative justice will need to grapple with in the 21st century. Besides imparting the basic skills of mediation to the participants who have come from a number of publics, it is my fervent hope that this 10-day program will give the participants food for thought on how mediation, which has limitless remedial imagination, can be made to serve the needs of this beautiful country. A country whose legacy in producing two of the greatest icons of negotiation in the 20th century, Mahatma Gandhi and Madiba Nelson Mandela, constitutes humankind's greatest hope for major moral transformations. Thank you very much.
Thank you, Doctor. That was such a comprehensive and important welcome. And because we have so many international trainers, guests, it's useful to have that context. Our next speaker, I'm really honored to welcome Judge Jody Kollapen. Judge, I haven't yet had the benefit of appearing before you, but I have followed your career closely over the years. For our international trainers and those who may be less familiar with Judge Kollapen, Judge is currently a judge of the North Gauteng High Court and has also acted as a justice of the Constitutional Court. Judge Kollapen has been reappointed as the chairperson of the South African Law Reform Commission. And before then, Judge Kollapen served as the vice chairperson of the Law Reform Commission since 2013, before his promotion as chairperson with effect from 2016. Judge, congratulations on your recent reappointment some year and a half ago now. Judge Kollapen obtained his LLB and B. Proc degrees from the University of the Witwatersrand. He practiced as an attorney in Pretoria for many years and has always focused on public interest litigation. The judge has joined the Public Interest Law Clinic, Lawyers for Human Rights, where he coordinated the program known as Release Political Prisoners, which championed the rights of South Africa's political prisoners. Judge Kollapen was later appointed as the National Director of Lawyers for Human Rights. He has also joined the South African Human Rights Commission in 1996 as the first commissioner of the commission, and was also appointed as the chairperson of the South African Human Rights Commission a decade later in 2002 to 2009. Judge Kollapen has served on various boards and statutory bodies, which I won't relay. These include the National Advisory Council of Correctional Services, the International Board of Article 19 based in London, the Legal Resources Centre Trust, and the Foundation for Human Rights. He has previously served as an extraordinary lecturer in the Centre for Human Rights at the University of Pretoria. Judge, we are delighted to have you join us today. Thank you.
Thank you for that warm welcome as well, Shaista, and thank you for the invitation to say a few words on the occasion, or really the opening session of this very important mediation training program that will kick off shortly. Allow me to firstly acknowledge my boss, the Judge President of this division, Justice Dunstan Mlambo, Mr. Mohamed Keshavjee, who really has been the energy and the force behind this program from an international perspective, Ms. Kathleen Matolo-Dlepu, Chair of the Legal Practice Council, Ms. Nasreen Rajab-Budlender, the Vice Chair of PABASA, and then importantly, the international trainers who have given of their time, led by Richard Harding, and whose efforts over the next 10 days we anticipate and we wish to thank them in appreciation for. Given the fact that we're running slightly later, I'll try and keep my remarks as brief as possible, and just to make a couple of points that really provide the context for this training. South Africa's transition to democracy said to the world that we're a society that has the capacity, even in the most adversarial and formidable of circumstances, to find a way to talk to each other and to negotiate a solution that we could live with. And adversaries who were on extreme opposite sides of the divide found in themselves the ability to come together and to negotiate the settlement, flawed as it may have been, that saw the transition to democracy in 1994. In that process, and given the compromises that had to be made, we were mindful that the law would play center role in how we transformed as a society. And in many respects, our constitution, recognized as one of the most progressive in the world, was regarded as a promissory note to the future. So the constitution offered the promise of a better life. And so for those of us lawyers and steeped in the legal profession, we understood then that the law would play a vital role in this process of transformation. I don't think we ever imagined that it would play the kind of role that it is playing today. The recourse to the law, which is commendable, but perhaps on the downside, the recourse to litigation. And indeed, we've become quite a litigious society. And one wonders that a society that was born really out of mediation could evolve to becoming such a litigious society. And L.B. Sachs, in the earlier discussion he had with Mohamed Keshavjee, alluded to the fact that mediation, for some reason, ranks very low in our list of priorities. I was wondering why that is so, and maybe a few reasons come to mind. I think pre-1994, we lived in a society where the law was seen as a tool of social destruction. It was in the name of the law that so much that went wrong in a society occurred. The hierarchy of humanity, the destruction of lives and livelihoods, all took place in the name of law. And so post-1994, we were entitled to see the law as rather a tool in the social transformation of our society. So the law became important. Secondly, we saw institutional change, and all of a sudden, not overnight, but the courts were now being staffed by people who looked like us, who shared the same values that we shared, who fought alongside us in the struggle. And so the credibility and the legitimacy of the courts enhanced, and people were more willing to use the courts than they were before. Thirdly, I think we recognized that a new legal framework, that was the Constitution, simply represented the skeletal structure of the legal order we wanted to create. And to provide the flesh for that, you needed to take cases and you needed to develop a jurisprudence that would stand the test of time. Fourthly, we also found that in many instances, government may have been unwilling to take difficult and controversial decisions and would prefer to kick those down to the courts to decide. So the issue on the death penalty, for example, and many other issues. So in the last 27 years, courts and the adversarial system of litigation has really taken center stage, but it has come at a great cost. It has come at a cost to our society that we've neglected mediation processes that were very much evident, not at a formal level, but at an informal level pre-1994. You'll recall that communities who couldn't trust the justice system would create their own capacity pre-1994 to resolve disputes in a way that was just and equitable. So we've seen the downside of this lack of capacity, where there's an increase in adversarial litigation and increased polarization in society, but also the inability to mend personal relationships that otherwise should have been capable of being mended. We've seen how courts have been overwhelmed with cases, many of which don't belong there. And scarce judicial resources have been allocated to litigation that could have been resolved through mediation. I think in addition, the judiciary has increasingly been called to play a role in the resolution of political disputes. And that's come with its own cost, because inevitably the judiciary would stand accused of playing politics. That charge was almost unavoidable. And Dennis Davis and Michelle Leroux write about this in their book called Lawfare, the downside of that kind of litigation. And I think, speaking as a judge, one also experiences a high level of judicial frustration as cases come before you that are eminently capable of being mediated, but where you, as a judge, are forced to deal with it within an adversarial system. Sometimes there's an element of judicial bullying that happens that pushes the parties to try and resolve a matter. And so we're in this bind where we haven't embraced mediation, but there's some signs of change. The rules of court now require parties before the inception of litigation to indicate what measures they've taken with a view to mediating the conflict. There's the work of the Law Commission, which I chair, which may be looking at suggesting that certainly in family disputes, matters would not come before a court unless there was a resort to mediation, or unless the parties were able to convincingly explain why mediation was not an option in those cases. And I think there's the growth of informal mediation as people see the cost and the damage caused by adversarial litigation. I'm not suggesting that there's no place for that. But I think in all of this, and as we start this program, we do need to recognize that we cannot encourage a culture of mediation through coercion. It's contradictory. We have to do so through persuasion, and I think there are enough reasons why we can persuade the legal fraternity and those beyond that of the benefits of mediation. So as we start this program, let me then indicate that it could not have come at a better time. I think we, in many respects, politically and otherwise, reached a crossroads in our society where we could be described as a society maybe at war with itself. And we need to find a way to talk to each other. Litigation has not helped us. It has provided us with legal solutions, which may not always be the most effective solutions that our society needs. And so beyond these 2 weeks, Mohamed has indicated some of the challenges we face. And I think I want to associate myself with that. How do we look at the most appropriate regulatory framework that would assist us? How do we develop the kind of capacity that is sustainable? How do we monitor and evaluate what we do? And in all of this, I think those South Africans who were part of the conception and the development of this program have a critical role to play. At the end of the day, the extent to which we own such a process will depend and will shape its success. In saying so, I'm eternally indebted to the international team and will continue to call upon them. But I think they've opened a wonderful opportunity for us, and how we seize it, embrace it, and take it forward is left with us. But I feel heartened that those who've participated in the conception of the program so far, those who've elected to participate in this first training session, will form the core of the cadres who can take this process forward. So I'm excited about it. Thank you very much for the opportunity to say a few words, and thank you for our international partners for so willingly being able to give just not of your time, but really of yourself, because I think in spending this valuable 2 weeks with us, you give more than just of your time. It's really a commitment that you demonstrate compellingly to our country, to its people, and to the interests of its people. So thank you very much.
Thank you so very much, Judge. And thank you also for framing the value of this course within our profession and within our context. Indeed, all too often litigation entrenches the view of in-group and out-group perspectives, rather than creating a collaborative space where really tough and ongoing problems are seen as challenges in which we work together to find common solutions that are suitable to the context and to our communities. Our next speaker is Mrs. Nasreen Rajab-Budlender, SC, a founding member of the Pan-African Bar Association and the current chairperson of PABASA. As some of the judges and legal practitioners may be aware, PABASA was founded as the first bar association of advocates established post-democracy in South Africa, and which has its primary focus on the transformation of the legal profession to address the legacy of discrimination against Black practitioners and women practitioners in the profession. Mrs. Rajab-Budlender was admitted as an advocate in 2000 and joined the Johannesburg Bar in 2005. She holds an LLB degree from the University of Cape Town and an LLM from Columbia University in the United States. Nasreen has also worked as a clerk or researcher to our former Chief Justice Chaskelson at the Constitutional Court, and thereafter worked as his researcher at the Judicial Services Commission before being called to the bar. Nasreen's primary areas of practice include administrative law, constitutional law, commercial litigation, and environmental law. Nasreen has also acted on various occasions as a judge of the Land Claims Court and in the North Gauteng High Court. She is a panelist with the Arbitration Foundation of South Africa and regularly chairs in commercial arbitrations. Ms. Rajab-Budlender is also the deputy chairperson of the Gauteng chapter of the Legal Practice Council. Ms. Rajab-Budlender and my chairperson, we welcome you.
Thank you, Shaista. I have to start by saying it's very funny to hear Shaista call me Ms. Rajab-Budlender when she's generally busy screaming at me across WhatsApp, telling me what I've forgotten to do on a daily basis. So Shaista, thank you for that warm introduction. Good afternoon, everyone. I'm delighted to be here today and to have this opportunity to say a few words on what we consider to be a very special occasion. I know that I follow a formidable series of speakers, including Justice Sachs, who addressed our earlier session, for those of you that were there. And so I intend to keep my comments short. Let me also just begin by acknowledging and saying how happy I am to welcome our Judge President of the Gauteng Division, Judge Mlambo, who is here today, together with several of the judges of our High Court in Gauteng, and they are going to be attending the training. And so we're very grateful that you're all here and that you're going to participate in this. I think your participation in the training will add a huge depth and richness to the training and the other participants. So thank you for being a part of that. Our Judge President Mlambo has been very much at the forefront of spearheading High Court mediation in South Africa, and he really has had such foresight and vision in moving our courts progressively forward, that I think it's worth me saying on this platform that we as practitioners are so grateful for that vision that he's had, and it certainly has served us very well in the last few years, and the havoc that COVID-19 has wreaked on our court system. So I have full faith that he'll continue to move us forward as we go, and that he'll continue to help us to offer the best possible services that we can to South Africans who use our courts and require our skills and our services. And then thank you so much to Judge Kollapen, who has been a long time hero of mine, although we've never met in person, but I'm very grateful to you, Judge Kollapen, that you've been part of this process. And thank you so much for your words today, which has left us with a lot to think about our role, about the role of courts and of mediation. The other person I must thank is Ms. Kathleen Matolo-Dlepu, who's the chair of our LPC, and who I see in the last few minutes has been re-elected to the Legal Practice Council for the next round. And so we congratulations to you, Chair, and we're very grateful for the role that you've played in trying through the Legal Practice Council to unite and transform our profession, and all of the work that you do to empower women practitioners in particular. We recognize that, and we want to thank you for that. Now, as Shaista said, PABASA was a bar of advocates that we formed around the time that the Legal Practice Act came into effect. And I know that there are participants and trainers that are not South African, and so just to give you a sense of what that means, the Legal Practice Act changed the legal landscape, or how lawyers are regulated in South Africa, and united both attorneys and advocates under one regulatory body. That's the Legal Practice Council. And at the point that was happening, a group of us who were previously members of the Johannesburg Bar and had been for many years, realized that there was an opportunity to create a structure, a voluntary association of advocates that was different to the existing bar councils that had been in place for hundreds, I'm not sure exactly how many, but at least 100 years, and traditionally had been the home and regulatory body of advocates. And so we formed PABASA with a view to doing things a little bit differently, with a view to addressing squarely the issues that we felt we weren't able to address within the traditional structures. And those were largely around issues of transformation, of diversity and exclusion that Black practitioners and female practitioners felt within the profession. So PABASA was formed with an aim of transforming the profession, removing obstacles that Black and women practitioners experience in trying to not just survive as an advocate, but also to thrive and be successful, and to obtain the best training and skills that they can. So those were our primary motivations for starting Pabasa. We're a national bar, so we have members and chambers around the country, but we are still a fairly small bar. And with that in mind, we are attempting to use our very small voice to genuinely make a loud noise and a difference in the profession, and to achieve something that is sustainable and that would be real transformation. Now, alternative dispute resolution has been one of the pillars of Pabasa from its inception. And part of that is because we recognize the role that extracurricular dispute resolution can play in society. We already have an existing relationship with Equilaw and Conflict Dynamics, who run alternative dispute resolution programs. And we're in the process of setting up a panel of Pabasa accredited and trained mediators. And so this training that Dr. Keshavjee and his team are going to conduct is really, it goes to the heart of who we are as a bar and what we see our role to be. Someone said to me the other day that they were surprised that a bar of advocates whose bread and butter comes from litigation is actively involved in training mediators and promoting mediation as an alternative to court processes. And why were we doing that? Were we stopping ourselves from accessing work? Well, the answer for me is simple. There may be many answers, but certainly from our point of view in Pabasa, we see our role as advocates in large part to be about facilitating access to justice and to assisting the most vulnerable in our communities and in society with accessing that justice. And we recognize that litigation through a courtroom or through a court is not always the best way to achieve this. There are many circumstances in which it is the best way, but it's not always. And we're all aware, as Judge Kollapen pointed out, that there are many downsides to litigation, the cost of litigation, the delays, the long court rolls, and the overburdened judges and overworked judges. So we recognize all of that. And so we see mediation as a way of providing an appropriate way of resolving disputes that should not be in a courtroom. Judge Kollapen mentioned that there are circumstances in which judges sometimes can nudge parties towards mediation, where it's clear that the judge thinks that that's appropriate. Well, as counsel, I find that if we are open ourselves to the idea that that mediation may be appropriate or an appropriate way of resolving the dispute, I find myself increasingly advising clients that is something we should explore before we launch proceedings in a court, for example. And I think that in that way, we may well more often get a win-win situation for both parties than not. In the last session, Judge Sachs talked about a case that he was involved in that made him want to stop being a lawyer. And it was about a divorce. And that reminded me, actually, that I'd had a very similar experience early on in my practice, where I represented a father in a custody battle. There were two children involved, and both parents were fighting for custody of these two little boys. And I represented the father. And it was a fairly heated court process. And at the end, it was an urgent application. By the end of the hearing, and the end of this process, we were successful, and my client had won custody. And I thought, I was a young practitioner, I was new to this, and I thought, well done me, I've done well now, I've won this case for my client. And I turned around and looked at my client, and I realized that both him and his ex-wife were in tears. And I thought, what's the point of this? It can't always be enough to win in court. There has to be a better outcome that keeps people, or resolves things in a dispute, resolves disputes in a way that you can continue to live in a meaningful way and without so much hurt and distress being caused. So with that all in mind, when Hashila called me about 7 or 8 months ago and asked if Pabasa would be willing and interested in co-hosting a mediation training together with a group of international mediators, I jumped at the idea. It fits very well with PABASA and what we're trying to do. But I had no idea at the time how extraordinary this process was going to be. Because in the last few months, I certainly haven't had a very active role in the structure of the program, but I have been watching from the sidelines. And I really have been so impressed by this extraordinary team of people that come from around the world, from such different backgrounds, but who are giving so freely of their time and skills in doing this training. For those of the participants who don't know this yet, the mediators that are going to train you come from across the world. They are experts in what they do, and they've already done training from Afghanistan to Syria to Kenya. And I'm hoping that Dr. Keshavjee will tell you at some point some of his stories of training in some of these different places. They are fascinating, and they will hopefully inspire you to use mediation in whatever context you come across. So, yeah, so you're going to have a great program. It's going to start after the session, and it's a program that's been so carefully thought through and structured, and it's focused on teaching mediation, not just as a skill, but as an art. And embedded in this program is the idea of embracing cultural and human experiences and norms. And you'll see that I've encountered that just by engaging with the presenters that are going to train you, but you'll see that through role plays, they teach the art of mediation in a way that will allow all of you being trained to use the skill, take it back to wherever you come from and use it in different contexts to benefit so many South Africans. So with that in mind, thank you for giving me an opportunity to speak, and thank you, Dr. Keshavjee and the team for allowing PABASA to co-host this event. We're very grateful to do that with you. And I wish you well, and I know the training is going to be wonderful. Thank you very much.
Thank you, Nasreen. In response to your opening comment, I felt very awkward calling you Nasreen. But thank you for really framing the importance of the bar participating in an initiative like this. It is certainly very exciting, and it's certainly a first of its kind for what is seen as a purely aggressive, litigious profession that prefers nothing more than a win and lose on the briefs we receive. Our next speaker is, and our final speaker before the commencement of the course, is Ms. Kathleen Matolo-Dlepu. And the first thing we have to say is congratulations. The results of the LPC election came through about 40 minutes ago. And so we absolutely warmly congratulate you, and really the results of the election show the stellar work that you've done over the past 2 years in really bringing the LPC to being an important and working regulatory body for the profession. Ms. Dlepu is a practicing attorney and the founder and managing director of her law firm. She is also an accredited mediator and arbitrator, and thus is perfectly positioned to speak to the importance of mediation and the nature of this course at this time in the profession and in the context of the country. Ms. Matolo-Dlepu is, I don't know if I can say the current chairperson of the Legal Practice Council. I presume, or perhaps I'm anticipating, that she is now a member of the Legal Practice Council and previously held a number of key leadership positions in the legal profession, including being a co-chairperson of the Law Society of South Africa, the Secretary General of the Black Lawyers Association, and later appointed as the Vice President of the Black Lawyers Association. Ms. Matolo-Dlepu is a current committee member of the Judicial Services Commission and a non-executive director of the Attorneys Indemnity Insurance Fund. When not attending to these very onerous commitments, she is also extensively involved with community-based organizations that promote and advise on women's rights and gender-related issues. And she is also a member of probono.org. Ms. Matolo-Dlepu's commitment to the advancement and transformation of the legal profession has been recognized both in South Africa and abroad. Among the many accolades acknowledging her advancement of the profession, she holds the position as one of the most influential people of African descent in the Great Legal Minds Law and Justice edition in support of the United Nations International Decade for People of African Descent. And last year in 2020, she was admitted as a finalist in the Lifetime Achievement Justicia Awards from the Women in Law based in Austria. We are very grateful that you have given your limited time to speak to us at the commencement of this important initiative. We welcome you.
Program Director, the Honorable President Mlambo, Honorable Judge Kollapen, all the honorable judges who are present, Dr. Mohamed Keshavjee, and to our international trainers present, and Ms. Nasreen, Rajab-Budlender, and all the legal profession members who are in this virtual meeting. I greet you all. Thank you for affording me the opportunity to speak and welcome this long-awaited program. I mean, we discussed this program when I think I was only 3 months as the chairperson of the Legal Practice Council. So I'm really excited that finally we are there. I'm going to approach my address by looking at why the alternative dispute resolution is necessary in our legal system and how we can use it to facilitate access to justice in which types of disputes. Though not all arbitrators and mediators are legal practitioners, we can all agree that the legal profession, in most cases, is called upon to play this role. The Legal Practice Council, as a regulator of the legal profession, has a vested interest in how any form of dispute resolution and practice of law implemented in South Africa, and also how those practices affect the profession and access to justice. Mediation as a practice has been around for many decades, implemented in various settings of our lives. It is universally viewed as an efficient way to solve disputes, and indeed, it has changed the legal landscape as an alternative to having dispute being resolved in court. You will bear with me, I will use both mediation and alternative dispute resolution interchangeably, as one is a form of the other. I've been fortunate. I'm one of those fortunate ones who was invited to become involved in a formal dispute resolution program as a young female practitioner in the early 90s. So now you know my years, how old I am, in the early 90s. And I was trained, I was part of the trained mediators and arbitrators who were trained by the Independent Mediation Services of South Africa in Auckland Park, Johannesburg. We facilitated community forums to understand our interim constitution. Those were the years I still cherish, and that's where I developed my love for mediation. Then alternative dispute resolution was, and is still has been effective in addressing labor dispute, community dispute, and land claims. This resulted in the establishment of the Commission for Conciliation, Mediation, and Arbitration, which was established in 1995 and is used to resolve labor dispute. It is mandated to promote social justice and fairness in the workplace by delivering ethical, qualitative, and innovative and cost-effective dispute resolution services institution, education, training and development, and efficient administration. We have also previously had the National Land Reform Mediation Panel for land disputes. We have the National Accredited Board of Family Mediators, which is a national accredited body which promotes mediation and ethical standards and integrity of practicing family mediators in South Africa. These modes of dispute resolution that currently exist in South Africa include conciliation, mediation, fact-finding, arbitration, and these, the most utilized being the arbitration and conciliation. In 2014, the Department of Justice amended the rules of the court by inserting court-annexed mediation rules to be implemented in the district and regional courts, form part of the government's effort to transform the civil justice and enhance access to justice. And these rules are aimed to assist in the case flow management and the reduction of disputes appearing before the court. I do know that my JP, who was, by the way, my mentor when I was doing judicial training, is an expert in this. I mean, the case flow management is his baby, and we really appreciate what he has done so far. I'm also aware, as part of the training, you also delve in Rule 41A of the Uniform Rules of Court, which has been in effect since March 2020. And this has placed mediation in the forefront of the High Court legal procedure. I'm also aware that although mediation is not compulsory, I'm keen to hear the discussion that comes out of this training. I know that we cannot force parties to go into mediation, but I think we really need to promote it. I'm mentioning all this because South Africa is recognized as a leader in using mediation and arbitration to resolve labor dispute. We therefore need to work together to ensure that this recognition is extended to other types of dispute and can be referred for alternative dispute resolution. I'm referring to disputes such as contract claims, motor vehicle claims, neighborhood disputes, and family disputes. I see these as appropriate matters for mediation and should be dealt with by the courts that have jurisdiction in respect of the matters. These matters are common disputes that face many poor South Africans who cannot afford legal services or who do not have access to a free legal aid services. Members of the judiciary present today can attest that many lower courts will have a better case management if such dispute can be dealt with more through alternative dispute resolution. We need to broaden access to justice. One of the objectives of the Legal Practice Act is to ensure that the fees that are being charged by legal practitioners for legal services rendered are reasonable and promote access to legal services, thereby enhancing access to justice. We can all agree that the current structure of alternative dispute resolution in South Africa has, to a certain extent, enabled greater access to justice for the poor, in particular rural communities who struggle with the understanding of the formal court system, but still needs to have their dispute adjudicated upon. Alternative dispute resolution in South Africa has the support of the government, and have stated in various acts and rules that have been put in place. It will be important for all of us to ensure that we raise our awareness about mediation as a dispute resolution mechanism across all sectors of our society, by informing them about the avenues that are already in existence and the processes involved. We will do our part as a regulator, but also making sure that we protect and preserve the independence of the legal profession. I'm really proud of Kabasa for embracing this process. And this really talks to access to justice, which I'm really a proponent of access to justice. I think that's why, Honorable Justice Mlambo, you don't see me much in court, because I'm busy with alternative dispute resolutions. So I'll stop here and wish everybody all the luck. I've got about 9, because I believe in this process. I think all my directors, the PC directors, are part of this training. So we are going to encourage everybody to be part of this. Rest assured, the legal profession will embrace mediation. Thank you for the opportunity and good luck. Thanks.
Thank you so much, Ms. Dlepu. It's so wonderful to have your support and your encouragement, and also that you encouraged so many of your colleagues to join the course. It really changes the atmosphere and the tone of the course to have members and practitioners from so many different areas of the profession involved, and we really appreciate your time this afternoon. And again, congratulations on your re-election. I think you only came into the talk after I had congratulated you, so let me do so now.